Hello, my name is Ken Dost, D-O-S-T. Actually pronounced Dost, but I prefer the pronunciation of Dost. And actually Dost is my adoptive name. My actual live birth given name is Paul Anthony Geiger, son of Kathleen Marie Geiger, born in Cleveland, Ohio at the Paul Infant Home. And actually I have a relatively unknown of this clan. I have a brother and sister who, thanks to Kathleen, do not even know I exist. And thanks to Kathleen also, I have a birth father who thought I died at birth. So if if his names ring with anybody, hi Dad, I am actually alive. Anyhow, the reason why I mentioned the name Geiger as an interesting tidbit is going back into the lineage of Geiger. It goes back to a Gochian tribe, Bavarian tribe. Tracked it back to mid-1600s. Somebody had tracked it back. And one of the names within that lineage is actually eulogized one of the infamous Rothschilds upon their death. But no, I have not gained any advantages of banking. I have not, banking's not been a friend of mine, certainly. And if anything else, banking has been my enemy and the detriment of myself and many others. So, but I think it's a little interesting tidbit, going back into family history, unknown family history. Anyhow, I am not an attorney. I've never attended law school. I've never even taken any classes on law. So everything I'm talking about here is to be construed for entertainment purposes and is not intended to be legal advice to anybody. It is merely meant to lay out facts, actual material facts, and as to the mortgage situation and the mortgage fraud that I've uncovered. I'm not an accountant. I've never done accounting. I've never had education in accounting. I am not in financial services. I am not on Wall Street. I am not a banker. I'm not a broker. I have not in title. I'm not in settlement. I have not connected with the industry in any way, shape, or form. Never had any training in it, and have never been any part of it. So as a matter of fact, my background is in the field of architecture. So you may be saying, well, why are you talking about what I'm going to be talking about here today? What makes me qualified? And what makes me qualified is the fact that I've done research. And coming from a background of architecture, the one thing that I've learned in that field is how to design a building that stands tall and meets code and meets design criteria and CC&Rs and zoning regulations, so on and so forth. So what I'm here to talk to you today about is a trade secret. A big trade secret that I've uncovered after years of research, and that's specific to mortgage fraud, and specifically to fraud in general, economic fraud, if you will. That is far different than what is perceived out there in the general public. And millions of people have lost their homes, needlessly lost their homes to foreclosure, and it breaks my heart that some of these people that have been thrown out of their houses are older women, older ladies, older widows, people that are dying, that is still in hospice, that just want to die in their own houses, but still were tossed out. It's despicable, it's disgusting, and something has to be done about this. We have a court system, of course, that throws people out of their houses without any compunction whatsoever. We have attorney generals, we have departments of justices who complaints have been submitted to, and basically we get the don't let the door hit you on the ass as you exit type of attitude from these people. So we have a big problem here, folks, and the people that are going through foreclosure are well aware of how difficult it is and how frustrating and how angering it is. Now, what I've come across here in my research is everything that we understand to be paradigm is a fraud. It's a fake. It's a lie. It's a misinformation. And this is what we're here to talk about today. What my intention here is today is to set a ground, well, not ground rule, but set an introduction to future videos where I'm going to diagram out exactly what has been done to this country and the people of this country behind our backs, and that we're not aware of. So the trade secret, and this is what this all is a big trade secret, and news for the bankers. The gig's up. Once trade secret has been revealed and exposed, it's no longer a trade secret. And this is a trade secret that I am going to expose. And people are going to hopefully take a hold of this, and we can reclaim our country back and reclaim our rights back and our freedoms back. My information that I've come across here is all based on material fact. As a matter of fact, that's what we don't have right now. We lack an actual foundation of material facts. The fact that when we sign a mortgage loan agreement, and our perception and our belief is that we have ownership, that we have ownership of a house, of a home, and that we've achieved the American dream, is a lie. It is a paradigm that has long since died, and it has been covered up, and it is an evil deception upon us. So when a mortgage is foreclosed upon or defaulted upon, what's going to be laid out here, and what's the foundation of actual fact is going to show that every single one of these foreclosure mill scum attorneys will be proven to have committed fraud based on the actual foundation of material fact. It will reflect that what they have done is intentionally filed actions on fabricated documents, which they know are fabricated, yet they are bringing into court and claiming as being the originals. These are in agreements and documents that will begin to make more clearer to you as I explain this and as I go through this and in future videos. What there is a complete lack of transparency. What I mean by complete lack of transparency is when you sign a mortgage, you're entering into a process. So when you sign what you think is a mortgage loan, you've set yourself into a set of processes and a set of sophisticated methods and methodologies that we were not made aware of as the consumer. As a matter of fact, we were intentionally made ignorant of what's really going on here. When we sign our mortgage loan agreement, we expect, we think that on the basis of what our understanding of securitization is that the mortgage loan will be sold to an investor who will pool other mortgage loans together, and this investor will be a Wall Street bank or somebody associated thereof, and a special purpose vehicle will be established. The pool of loans transferred to that, out of which certificates are sold to investors. Now that is by and large basically true. It is also by and large a lot of baloney, actually. It is the original definition going back to 1975 with Louis Renoir, if I pronounce his name correctly, and which still holds kind of true today. As a matter of fact, most practitioners and academics will still say that that is the definition of securitization. And they're wrong. They're dead wrong. Securitization goes far, far beyond that. And those are the things that we have to understand here. That what we signed was not a traditional mortgage loan. What we signed was a basket of securities that were not for our benefit, but were for the benefit of persons who have taken rights in our property. Now, if you look at your note, if you put your note and your deed of trust alongside one another, what you'll see is that the word note holder is consistently restated throughout your note, but you don't see that in your deed of trust or mortgage. You'll see the word note, but you won't see the word note holder. At least I don't believe you will. And you also see the word proceeds. Proceeds, ladies and gentlemen, is a creature of UCC 9. So you've got a deed of trust that is structured entirely around UCC 9, and then you've got a note that is structured as a negotiable instrument, in terms of a note holder. So what you have is you have two separate instruments here. And what they're doing is they're coming into court and claim that they have bearer, a holder and bearer, and under UCC 3304, I think is correct, basically says that as long as they're the holder in possession, they can take your home away from you, whether they came into possession legally or not, doesn't really matter. And that's the problem we face in the courts. The problem we face in the courts is it's believed that we have signed a valid mortgage loan agreement, and the courts are just simply not going to award what they see as being a free house on an assignment that is, one, can't be challenged according to some courts, and according to a lot of courts, we can't challenge it because we're not part of the securitization process. And that's frankly bullshit. We've got 8 years of case law, all bad case law, because we lack the foundation of material facts. And what are the foundation of material facts? The foundation of material facts is that we have signed into a sophisticated set of programs that we have no knowledge of, and that we could not possibly have had any knowledge of. Thereby, we could not have possibly completed a competent due diligence, which is our responsibility to do as freedom to contract, and in signing that mortgage loan. Now, interesting enough to freedom of contract. Let's talk about that for a second. The Fannie and Freddie Standard Uniform Instrument is used in almost 100% of transactions. It was designed to be consumer fair and friendly. That is to say, all terms and conditions are to be easily understood and spelled out clearly within the four corners of the contract. And that was by mandate and by Richard Nixon, of all people. I'm not a crook, that person. And it was. I mean, we can thank Ralph Nader for ensuring that the instrument was properly vetted, and all the hidden terms and small, actually, obviously, the small print is gone, but that contained no hidden terms. And that held true, I suppose, until the addition of Mortgage Electronic Registration Systems, Inc. was added in 1997, 1998, 1999, somewhere thereabouts, and that was the big caveat that kind of killed the dog, so to speak, but it didn't kill the contract, because as we enter here into 2015, the Fannie and Freddie Standard Uniform Instrument is still seen as being an impervious contract. But the fact of the matter is, nobody's challenged the contract, and that's another issue. Why has foreclosure defense not gone and looked at the contract and researched the history on the contract, assuming instead that it is a valid contract? Now, we've gone back and forth in the courts about Mortgage Electronic Registration Systems, Inc., and it's in some states, like in Oregon here, they're no longer allowed to perpetrate non-judicial foreclosures, so they're coming after the lien now judicially. And which is really, the point is anything around foreclosure defense, we're going to lose. We just can never win as long as there's a valid agreement in place. And folks, there is not a valid agreement in place, and that's what these videos are going to expose and are going to talk about. And like I said, today is just kind of an introduction, just to kind of just give a general overview of what we're talking about here. We're talking about securitization and the real definition of securitization. The definition that we think it is, that we're told it is, or our perception is geared towards, it's custom fitted around Bank of America, it's custom fitted around the banking industry, it's custom fitted around the insurance companies, it's custom fitted around Wall Street, and anybody that is in this chain of payments and the payment stream, revenue streams, compensation streams, which are rights and property, which are established through the unseen contracts and undisclosed underlying agreements and accommodations behind the door of MERS, essentially, and behind the door of MERS trademark. Now, what we're going to talk about is very complex. It's a lot of details, but the basic gist of this is that we did not sign agreements that we understood, that we were fully disclosed of. Mortgage Electronic Registration Systems, Inc. is not a utility function of Fannie and Freddie, as so many people were represented, as was represented to so many people during the close. I remember in our closing, that's how it was represented. It was represented that Fannie and Freddie, MERS is just a utility function of Fannie and Freddie, just to track mortgages. Very nonchalant, very believable, and we went along with it, just like millions of other people went along with it. And here's the thing about Fannie and Freddie were the staple are the staple of the American housing industry. Yet they pulled a fast one on us, folks. They pulled a fast one on us. They sponsored MERS basically, and MERS is a licensing agent. It is a licensing agent of information, and it is hidden behind the Mortgage Electronic Registration Systems, Inc., which is the mortgager that is recorded to the county is the MERS Circle R system. MERS Circle R system, MERS trademark system. And this, there's an underlying agreement that is posted underneath the MERS trademark on the USTPO. And if you want to find it, it's posted. I think the location is posted, and the documents are posted actually in my file section on my Facebook page, Mortgage Equals Copyright Derivative. It is a concealed trademark that is, if it were disclosed within our Fannie and Freddie standard informing documents, we would not be where we are today, folks, because nobody would sign these agreements. And somebody in consumer protection, or somebody, Ralph Nader, for all we know, would have come forward and said, hey, this is not fair. What people are signing here is people are signing away the rights to their lives. And that's exactly what we did when we signed that agreement. When we signed that agreement, we created what was a document. We put a signature to a copyrighted document, which creates essentially a derivative, the most basic form of a security, folks. And it's even more so a derivative once it's converted to an electronic format. See, the paper document that you sign, they want us to believe that it's a negotiable instrument. And they just toss it on the back shelf. But everything that goes into our loan, the underwriting of our loan, the credit analysis of our loan, the risk analysis, everything about our loan is it is based upon technology. And I came across another interesting definition of derivative here, which is from a patent that is a lender's residential asset company. And they define derivative as another type of information is derivative information that is derived and or inferred from direct and indirect information. Derivative information involves some processing and decision making about the data, but is generally as available as the direct or indirect information sources themselves. Examples of derivative information include information derived by applying trending algorithms or other statistical algorithms to historical property sales data. So what's going on here, folks, is when we signed our mortgage loan, our alleged mortgage loan, we gave away our signature. We allowed them through the MERS concealed agreement with Nations Bank that they could take our information and use it in any manner, shape, or form that they wish. That is to say, they can collateralize it, and they do collateralize it in structured financial instruments. Now, securitization is taking a financial. Now, the real definition of securitization, you get down to the gnat's ass about this, and you sweep aside all the BS, and you get into the details of this, is derivatives, is options and derivatives, and are all forms of securitization. The one thing that defines securitization is a financial instrument that is broken down into components, that is stripped into components. And each component, each one, has two separate subcomponents. One is an option, or years in terms interest, and the other one is a remainder interest. So, when you signed your mortgage loan, what you did was you were not given a loan. You were given a conditional sale. Somebody bought an option to your loan, maybe for just a couple $1,000s. And it's because everything here that we're dealing with is not in the here and now, it's all in the future. So when you sign a mortgage loan, somebody's betting on you in the future that you're going to default and when you're going to default, so that they can come in and then they can buy your loan. That's when your loan closes, folks. Your loan closes with that assignment of deed of trust, which is the first sale, which is the transfer of title, which is your moment in the sun, so to speak, when you actually have a loan that is then liquidated, and of course they get all the proceeds of it. And the key word again is proceeds. Proceeds is a very key word because we're talking UCC 9. We're not talking UCC 3. And UCC 9, we're talking general intangibles. Of general intangibles include patents, trademarks, copyrights. And now we're talking patents. Patents are processes that are to underwriting, to all different types of systems that make up these mortgage loans. And what it is we think that we've got a mortgage loan, but we didn't get a mortgage loan, folks. What we bought into was a lure into giving over our signatures so that people can bet on us. And they can bet on when we're going to fail, and they can give away all our rights and property. They can make us a lessor upon our own land because we don't have a sale. There is no sale until the actual sale, the actual consummation of your loan really doesn't occur until that assignment of deed of trust when you default or they default you. So what they're doing is they're taking they stripped you of your ownership, they took your ownership, and they're selling it in like it's a book for fees, compensation, for bonuses, and they're giving rights in that property to everyone and anybody that's within their chain of their private chain, that's to say, the chain of businesses. Now, giving an example of how important and why trademarks and why technologies are important. Own It Mortgage Loan. Own It Mortgage Solutions was the loan product that we had got sucked into, and it was under the product name of the Right Loan. Now, this is very important here because you and I didn't think nothing of the Right Loan. The Right Loan was a proprietary product. It was just a loan product of Own It, but in trying to get a trademark registration, Stephen Foster, a trademark attorney for the USTPO, and multiple refusals to issue the trademark to Own It, states this. Applicant also, and that's the applicant being Own It Mortgage Solution, applicant also argues that purchasers of its services are sophisticated, making confusion less likely. However, the recited services of the respective parties, that be their loan origination platform, are not limited to professionals with extensive experience in the trade, but are stated broadly and would include services offered to ordinary purchasers, that's you and me, folks, who may obtain mortgages only a small number of times in their lifetimes. It may be presumptuous to believe that these purchasers are sophisticated or experienced in these matters, and indeed they may not be. Even assuming arguendo that they are sophisticated or knowledgeable in the applicant's field, so that would be Own It Mortgage Solutions, loan origination field, this does not necessarily mean that they are sophisticated or knowledgeable in the field of trademarks or immune from source confusion. So you see, folks, by not disclosing the MERS circular, the MERS trademark to us, we were not able to source the products that we purchased. And when we signed that mortgage loan agreement, we were buying a product.